Welcome to This Moment in Democracy. I'm Saladin Ambar. This episode was recorded on July 6, 2023. In a contentious decision last week, the Supreme Court effectively ended affirmative action in universities. What is the impact on higher education and the broader repercussions on American society as a whole? Joining us today to discuss this is the former Vice Dean and current Professor of Law at Rutgers Law School and diversity consultant, Stacy Hawkins. Professor Hawkins, thank you so much for joining us.
Thank you for having me. It's great to be here.
I realize you've been undoubtedly going about the country, whether by foot or virtually, to talk about this decision. Could you just summarize for our audience what the court ruled, and if there is any wiggle room, if you will, for universities to continue to consider diversity going forward in their admissions?
Sure. So this was the fifth time in 20 years that the Supreme Court has had occasion to review the admissions policies at colleges and universities. And so the first time they did so was back in 1978. And there was really since that time an understanding that colleges and universities were allowed to consider race as one of many factors when making admissions decisions in the interest of trying to achieve student body diversity, so long as they did so in kind of a flexible and individualized way. That was really the kind of understanding, although there was not a formal holding on behalf of a majority of the court in that 1978 case. Fast forward to 2003, and a majority of the Supreme Court, a bare majority, but a majority, 5-4, really adopted that understanding from 1978 and formally made it the rule of law that at least under our constitutional guarantee of equal protection, public colleges and universities were able to continue to use race in their admissions practices, as long as it was one of many factors, and they were doing so in the interest of achieving student body diversity. Again, since 2003, that holding has been affirmed repeatedly by the court in a number of cases. In fact, in 2003, there were two cases, both of which were against the University of Michigan. But again, the court affirmed that kind of understanding of how race may be used in 2013, and then again in 2016, in cases involving the University of Texas. The Supreme Court once again affirmed that understanding of colleges and universities' ability to use race in a very narrow and circumscribed way in the interest of pursuing the educational benefits that flow from student body diversity. But since really the 2003 decision, opponents of race-conscious admissions have been persistently challenging those admissions plans and trying to get the court to either kind of restrict their holding in those past cases or even outright overturn their holding. And they finally succeeded. And so in this set of companion cases involving Harvard University and the University of North Carolina, the Supreme Court finally said that colleges and universities may no longer consider race even as one of many factors in their admissions practices. Instead, they have to use what the court calls race neutral means, even if they are pursuing an interest in student body diversity. And quite frankly, in this case, this kind of set of cases, the court even kind of impugned colleges and universities' interest in even trying to achieve student body diversity. But notwithstanding that, they really did focus on this idea that whatever the ends that colleges and universities were trying to pursue by using race in admissions, they are no longer permitted to do so. And to your point about whether or not there is any kind of residual ability to use race, the court did say that they can consider race if it is brought up by the student in the application as relevant to their own identity and their own experience, but colleges and universities may not use the mere fact of a student's race, which is provided through a kind of checkbox self-identification mechanism in their admissions decision. So they cannot consider the mere fact of a student's race, but if a student brings up their own racial identity as part of explaining who they are in their admissions application, then colleges and universities can consider that information.
Thank you. That's a very concise and I think very eloquent summarization. So I really appreciate it. What does this mean for Rutgers University and other public universities like Rutgers, particularly one as diverse, perhaps the most diverse, at least by some accounts, of colleges and universities, which Rutgers has been named in the past? What does that mean for places like Rutgers, but also private universities, say folks down the road at Princeton or other private universities? What does that mean for those kinds of places?
So it really does depend on how a college or university currently conducts its admissions practices. So the National Association of College Admission Counseling did a survey most recently, I think in 2019, and found that nearly 60% of colleges and universities report that race plays no part in their admissions decisions currently, right? So even before the Supreme Court issued this opinion. And the reason is that the vast majority of colleges and universities in the United States are not highly selective. The majority of colleges and universities admit most of their applicants. In fact, the average admissions rate in the country is about 60-something%, which is, I believe, the admissions rate at Rutgers, which means that if race figures in at all, it figures in much less prominently than it does for highly selective schools like Harvard University, which only admits about 3% of its class, or even a school like UNC, which admits closer to like 10 to 12% of its applicants. And so it really just depends on whether or not you are one of those schools that has a pretty high admission rate and does not really use race as one of the factors in selecting students for admission, or if you are one of the more selective colleges and universities that really does have to winnow down a huge applicant pool to a very small number of admitted students.
Thank you. And you mentioned it in your earlier remarks that equal protection under the law was sort of the linchpin behind the court's opinion. Can you share how the 14th Amendment was used in this decision? And I guess I use the term use somewhat advisedly. Can you share with us how the 14th Amendment came into play in this decision?
Sure. And it's worth noting that the 14th Amendment was deployed very differently by the majority than it was by the dissent. They had two very different kind of legal and historical understandings of the context, the kind of impetus, and the meaning of the Equal Protection Clause. And so on behalf of the majority, Chief Justice Roberts really emphasized the fact that the 14th Amendment Equal Protection Clause was designed to enshrine a colorblind view of the law into our Constitution. That is, it was supposed to guarantee that the law could not make any distinctions whatsoever on the basis of race. And interestingly enough, his chief kind of source for that claim was a very famous dissent in a very famous case back in 1896, where in Plessy v. Ferguson, the court actually upheld Jim Crow segregation, finding that it did not offend equal protection for mostly Southern states to pass laws requiring racial segregation in public life, because they said as long as there were equal opportunities for Black and white persons to, in this particular instance, ride on the railway or to go to schools, different racially segregated schools, but schools nonetheless, that was not prohibited under the Equal Protection Clause. But Justice Harlan, John Marshall Harlan, dissented in that case, and he famously wrote the words that our Constitution is colorblind and neither knows nor tolerates classes among citizens. Again, he was in the dissent in that case. That is not what a majority of the court held. And in fact, we know that Jim Crow and racial segregation prevailed for another half century or more until the 1950s, when in Brown v. Board of Education, the court first struck down racial segregation in public education. And then after the civil rights kind of movement began to not only decide cases, but also pass legislation prohibiting racial discrimination in public life. And so it really is a bit ahistorical, and also not legally accurate to say that the Constitution and the 14th Amendment has been colorblind. But that's what Chief Justice Roberts and the majority said, that really the whole design of our Constitution and the 14th Amendment in particular was supposed to be about ensuring that we can make no distinctions between persons on the basis of race, notwithstanding the fact that the 14th Amendment is part of the Reconstruction Amendments that were designed precisely to elevate the status of the former enslaved persons, right, to equal status with white citizens, and to do so in a way that acknowledges their past racial mistreatment of Black enslaved persons. Justices Sotomayor and Justice Jackson, who wrote in the dissent, acknowledged that history and acknowledged the fact that this colorblind vision of our Equal Protection Clause had actually never been the majority view of the court in its original interpretations of the 14th Amendment, and was inconsistent with really the lived history and experience in the country, where, again, we lived under Jim Crow racial segregation for nearly 100 years after the 14th Amendment and emancipation. And then we continued to engage in race-based remediation, right, through affirmative action and other means, even after that. And so we have never adopted a colorblind view of our constitutional guarantee of equal protection, yet that's what the court imposes on us today.
Another issue that arose in thinking about and arguing over the nature of the decision, the arguments used, was this question of standing. And I don't know how many of our listeners are astute followers of the court or the law. I suspect many are, given who our audience is. But could you share with us how this controversy over standing and whether or not the plaintiff or plaintiffs had standing to actually appear before the court with this accusation, if you will, against Harvard, how that came about, and what is the controversy? Is it worth digging into at all?
Sure. So standing is a procedural concept that says before a court can decide a legal matter, the parties before the court have to be the right parties to bring the issue. In order to be the right parties, they have to essentially have been injured by something that the other party has done, the party that they are suing. And that kind of dispute over the harm has to still be live. That is, the defendant could not have made the plaintiff whole in some way. And there must be some remedy that the court can provide to the party for the injury they have suffered. That's basically the idea of standing. And if those three things are met, that the person has been injured, that the injury remains a live controversy, and that the court can grant them relief, then they have standing to sue. And so in a lot of these cases about college and university admissions in the past, one of the challenges to standing has been that it really is the case that because litigation takes a very long time, oftentimes the litigants are denied admission to a college, they sue, but by the time the case gets to the court, they've actually graduated from some other institution, right? Which is what we call a moot question, right? There is no ability for the courts to give them the relief they seek, which is admission to their college or university of choice. However, the court resolved that issue in the very first case that they heard around this issue, basically saying there are certain types of injuries that will continue to occur, but they will evade judicial review because they will always take, right, a longer time to litigate than the injury persists. And so the court said that that represents a special class of cases. And so these cases have always been heard by the court. The other particular standing challenge in this set of cases is that for the first time, these cases were not litigated on behalf of an individual plaintiff who was denied admission to either of these colleges. Instead, they were filed on behalf of an organization, quite frankly, an activist opponent to affirmative action, Edward Bloom, who created this organization, Students for Fair Admission, for the very purpose of challenging these admissions plans and actually sought plaintiffs after the fact, right? And so they really did create these organizations as a vehicle for litigating challenges, and then, identified potential plaintiffs. And so these were unique in that they were organizational plaintiffs. And so organizational plaintiffs have to represent individuals who have the same kind of standing interest that an individual litigant would have. And at the time these cases were filed, it was not clear that the organization Students for Fair Admission was actually comprised of applicants to Harvard and or UNC who had been denied admission. But it seems that they really remedied that defect over the course of the litigation. And so by the time even they got to trial in these cases, the trial courts had found that that they did really have standing. And so it really was a non-issue. It did not remain a major issue on appeal. And so, of course, the Supreme Court quickly dispensed with the standing concerns.
Understood. Thank you for that response. We all know that no community is a monolith, and yet there have been lots of arguments put forth by and perhaps on the behalf of Asian Americans who have been seen as or have it's been argued that they've been negatively impacted by affirmative action policies over the years. What do you say to groups like the Chinese American Citizens Alliance of Greater New York, for example, who say they've been, arguing on the behalf of those who've been, quote unquote, victimized by these affirmative action policies in the past and are welcoming the court's recent decision?
So it's so interesting because what I would say and what I hope people who feel aggrieved by these race-conscious admissions policies understand is that SFFA's own evidence submitted at trial, the arguments that they made demonstrate that the harm to Asian American applicants in the admissions process, at least at Harvard, because they were largely the kind of party and interest in the Harvard litigation, the harm to Asians in the admissions process at Harvard comes not from race-conscious admissions that might benefit Black and Hispanic applicants. Instead, the harm to Asian American applicants at Harvard comes from the preferences that are afforded to largely white applicants who are athletic recruits, who are legacy admits, who are donor admits, or who are on the deans or who are children of faculty and staff. And that was called the ADLC list at Harvard. And it is that set of preferences that statistically disadvantages Asian Americans, not race-conscious admissions. And so by their own evidence, they were attacking the wrong target in terms of what's hurting Asian Americans. And so I think that it's just a false narrative that's gotten perpetuated, notwithstanding the very clear evidence at trial and on the record that eliminating race-conscious admissions is going to do nothing to minimize the harms that Asian American applicants suffer from the preferences that are given to those other applicants, none of which are going to be affected by the prohibition on race-conscious admissions.
I suppose so much of this conversation and indeed this ruling comes down to perceptions. I teach at Rutgers University. And I think most of people around the country who know anything of Rutgers would assume it's a liberal, progressive / very diverse institution if they know anything at all about it. Yet, I teach an American presidency course that might have 40 or 50 students, and there might be one African American in the class, maybe two at times. And so that's, but the perception of how affirmative action is benefiting Black students is always an intriguing one, to say the least. What do you suppose will happen to African American applicants going forward, particularly at elite institutions, the Harvards and so forth?
So that's a great point, Dean. And the reality is that people assail race-conscious admissions policies, but the fact remains African American students remain the most underrepresented racial and ethnic demographic in higher education, and Hispanic applicants second. Actually, Native Americans, I think, which tend not to be counted because they appear in numbers so small that they're not statistically reliable. But African American and Hispanic students are the only population that are actually underrepresented in higher education. And so, notwithstanding race-conscious admissions, they are still not being admitted in equal numbers to their white and Asian counterparts. And that picture is going to become even worse now that certain colleges and universities are going to be prohibited from using race in admissions to reach even that minimal threshold of underrepresentation, right? They're going to be even more grossly underrepresented in higher education, as you say, particularly at elite colleges and universities, because, what we know is that this is really not about, how many people are going to go to school. It's not likely to impact how many students go to school. It will impact where those students go to school. And again, we understand that there are lots of advantages that attach to matriculation at elite colleges and universities. They often have higher graduation rates. And so I do a presentation around race-conscious admissions that shows one of the reasons why it's so incredibly important to have the ability for select colleges and universities to use these race-conscious admissions is because if Black and Hispanic students are not able to attend those schools, their chances of graduating with a bachelor's degree dramatically decline because they get pushed down to lower ranked institutions that have lower graduation rates. And again, graduation rates are also variable by race and ethnicity. So Blacks and Hispanics already have lower graduation rates. You push them down to less selective institutions where their graduation rates are even less likely. Again, it just decimates their ability to obtain a bachelor's degree. And so if we're talking about creating an educated class of diverse students who are going to be able to satisfy our needs in the future workforce, our needs for future leaders of our democracy, this really is going to impair our ability to create that kind of robust, diverse pool of future leaders and future professionals.
I don't know if President Holloway has asked for your opinion or anyone else at admissions or elsewhere has asked for your opinion about how the university might move forward in what we can now call, at least for the time being, a post-affirmative action world. What can Rutgers University do? If you were asked by the president or of any institution for that matter, what can be done? But specifically, let's talk about Rutgers or like institutions, public universities across the country that serve their states and serve them well. What can those kinds of institutions do to ensure that they will continue to be robust institutions with great diversity and great students, particularly from the Black community that is, as you just pointed out, so often underrepresented at these kinds of institutions?
Absolutely. Well, one of the things that we know has worked in places that have demographic diversity, like Texas, like Florida, like California, are percentage plans. Those are one of the alternatives that are race neutral that was proposed by the challengers in these cases. And while it is not entirely within the power of university presidents to do that, it requires legislative action. You can certainly engage in advocacy to that end. And particularly for flagship schools like Rutgers University, that is probably the most selective school in the state and that might be most impacted by this prohibition on the use of race in admissions, ensuring that we are giving the best and the brightest students of every racial and ethnic background across the state of New Jersey an opportunity for admission to our flagship university, I think is one alternative. The other thing that we know really works and that is not prohibited by the Supreme Court's decision is engaging in outreach, cultivating a really strong pipeline of future applicants by working with and developing programs in targeted high schools where significant numbers of underrepresented minority students attend school. That is going to be one of the key things that, we want to do, make those kinds of investments in the pipeline to higher education in our state. And the final thing is really look at other considerations like socioeconomic diversity and other things that might be good ways of replacing the kinds of racial and ethnic diversity that are going to be lost through the school's inability to directly consider race and ethnicity in admissions.
Well, yeah. Well, it's interesting. You mentioned those percentage plans. It's been a minute since I've heard or read about those 10% plans that Florida and Texas had. They were very much a part of that 2003 conversation with the aforementioned cases discussed. Or I guess it was Grutter and Bollinger, or Grutter versus Gratz. I don't know. 20 years ago, those 10% plans or percentage plans were quite frequently invoked. So that's something to think about. I hadn't thought about that in some time. Listen, I talk to students as you do, all kinds of students, certainly Black students have expressed not only to me, but to many others, but certainly have shared their frustrations with, American society, frankly, writ large, let alone a university system that sometimes appears unwelcoming to them. I can attest that going to a predominantly white institution many years ago, sort of levels of discomfort that were quite challenging. What do you say to Black and Latino and other students who feel this decision is an affront to who they are, who feel targeted by this decision in a world where they already feel targeted, frankly? What do you say to them?
What I would say to them is that the Supreme Court, or at least those 6 members of the Supreme Court, don't speak for the majority of higher education. I think that if you look at the defenses on behalf of Harvard and UNC, if you look at the amicus briefs that were filed by countless colleges and university presidents, if you look at briefs that were filed on behalf of student organizations and students themselves, I think overwhelmingly, the population has spoken about the commitment that they have to the ideals of diversity in higher education. And I think that Justice Sotomayor in her dissent implored colleges and universities at the end of her opinion to not be dissuaded in their pursuit of student body diversity by the majority opinion. Yes, their efforts are going to be made more challenging. Yes, they are going to likely suffer some immediate losses, but I think that that's hopefully only going to be cause for them to double down and to really get creative and to really figure out alternative ways that they can continue to ensure that their campuses are reflective of the student body diversity that not only, their admitted students want, but that employers are looking for, from the schools that they recruit from. And quite frankly, as a public institution of higher education, that our democracy so sorely needs, in terms of cultivating the next set of leaders for our pluralistic society. And so I would say that don't be discouraged, because those 6 justices do not speak for all Americans. They don't speak for all of higher education. And I would say, do the work when you are looking now to where you're going to apply to school, where you're going to continue to experience your higher education journey. Make sure you're choosing based on colleges and universities who are demonstrating their continued commitment. And there are ways that you can identify schools that are doing that. Already, we've had a number of school presidents, including our own, make public statements saying that they are not dissuaded, in their quest for student body diversity by the Supreme Court's opinion, that they're going to do everything within their power and within the bounds of the law to ensure that they continue to recruit and enroll a diverse class of students. And that's what I think students should be encouraged by.
One final question. You've been so gracious with your time. Thank you again. We're talking with and have been speaking with Professor Stacy Hawkins. It's been really marvelous having you break this down for our audience. One final question. In the context of our multiracial democracy, what does this court decision mean for the country?
So again, I could be discouraged by the opinions of the majority and those of the concurrence. But what I choose to do is to be bolstered by, to be encouraged by the words of Justices Sotomayor and Justice Kagan in dissent. Not Justice Kagan, I'm sorry, Justice Jackson in dissent. Because again, they recognize that the court cannot simply will its way out of our racial problems in this society. They cannot impose colorblindness by fiat. We are not a colorblind society. As much as we might wish we were, or some of us might wish we were, we are not. We are not going to ever be likely a colorblind society. As Derek Bell famously said, right, the kind of permanence of race in this country is something that we will all continue to wrestle with. And I am encouraged by the fact that there are good people who are continuing to take up the cause for racial equality, notwithstanding the court's attempt to thwart it at every turn. And so, again, it's just like Dobbs' last term. You know, we could have taken a fatalist view of reproductive rights, but there were so many activists who came out and who said, we are not going to be deterred. We know what this country stands for. We know what we believe in. And quite frankly, what the Supreme Court did in Dobbs and what the Supreme Court did in the Harvard and UNC cases is counter-majoritarian. Those opinions are against the weight of public opinion. And I believe in the American people. And I believe that the American people's preferences will prevail, both with respect to reproductive rights and with respect to racial equality in this country. And we're not going to let 6 justices of the Supreme Court stop us from continuing to pursue the vision of racial equality in these United States.
Well, I will have to say that empowering and, dare I say, affirming message is one that we will have to, and I think rather gladly, end this wonderful conversation on. Professor Stacy Hawkins, thank you so much for joining us today on This Moment in Democracy. It's been a real pleasure listening to your insights. Thank you.
Thank you for having me.
Today's podcast has been brought to you by the Eagleton Institute of Politics. Eagleton is a nonpartisan research unit of Rutgers University, New Brunswick. This Moment in Democracy was made possible in part by the generosity of Gerald and Kiko Harvey and Eagleton's many supporters. To support Eagleton's work or sign up for its newsletter, click the links in the description. To learn more about the Institute, visit eagleton.rutgers.edu and follow Eagleton on social media. That's it for today. Thanks for joining us.